Georgia lawyers Bob and Irreverent D talk law. Listen up for stories about how things really happen in our legal system. Today, Bob and Irreverent D welcome attorney Anne Marie du Toit while they talk about the Solo Cup factory shooting and workman's comp. Now, sit back and take a listen as Bob and Irreverent D talk law.
All right, welcome to the Bob and Irreverent D Talk Law podcast. I am Bob Benjamin O. Benson. I am joined, as always, by our illustrious Irreverent D. Not Irrelevant D, Irreverent D.
I got you birds.
Dwayne Singleton. And we're joined by our special guest today, Anne Marie du Toit, a longtime friend of me. Like, we haven't been on the show before.
No, it's my first time.
Welcome to the show. Tell us a little bit about your law firm and your practice.
All right. I have had my own law firm with a partner of mine for about 4 years now. Prior to that, now I represent mostly people that are injured. Prior to that, though, I worked on the defense side. And so that's how you and I met, was
Right.
We were averse to each other.
We've had cases against each other. I had like injured workers and workers' comp cases, and you represented employers. Did you do, as a defense attorney, did you do liability stuff too?
I did. Yeah. On the defense side, I did car accident cases, slip and fall cases, that sort of thing. And so I did both. And then when we switched over, now we do.
Does your soul feel better now?
It feels good.
Okay, good.
Yeah. How do you like having changed over? Did you do plaintiff's work before you had done defense work?
No.
So you had been a defense attorney for a long time, and then you started doing plaintiff's work 4 years ago.
Yep.
Very good. How do you like it?
I like it. Yeah. It's different in ways that I didn't anticipate.
Mm-hmm.
On the defense side, you're reacting to things, where if you're on the plaintiff side, you're really coming up with creative ideas, and there's a lot more
Not making
creativity.
stuff up.
No, but you got to push the case, right?
Yeah.
Right. Yeah. Right. Yeah.
True.
A lot of people don't realize that. Like, as if I'm meeting with my client who just got injured, there are so many different ways that we can pursue the case, because we have to prove, we have to, like, whatever happened, right? However the accident happened, or wherever the slip and fall happened, it's already happened, and we're trying to figure out how to prove that. But the damages part, like how much our client was injured, how much medical treatment they need, or how their medical treatment gets done, it's not like we're making it up,
Right.
but we are kind of helping our clients from, with our experience, knowing, okay, well, look, if you're going to go in front of a jury, for example, and say that you're permanently maimed, you probably ought to have a doctor that says that, right?
Yeah, I can't remember where the kitchen is. I'm throwing up all the time. You may want to have that looked at.
Right.
Yeah.
You may want to have that looked at, because we're going to have to prove this later, right? Anyway, so today we're going to be talking about an interesting case that arose out of a shooting that happened in the Solo Cup factory. I'm not disclosing any private information. It's it's a published case. It's in the news. It's been a matter of public record. So what happened? And you're going to have to help me, Anne Marie, kind of go through the facts, because I have a cursory understanding of it. I think you've been more involved in understanding it because of a similar case that you're handling, right?
Right. Yeah.
So do you remember what happened in this Solo Cup factory?
So apparently there were 2 employees, and one of them found a bag. And so when he found the bag, it had some personal items in, and he went and he turned it into his employer. And then it turned out it belonged to a coworker of his. So the coworker got his bag back, looked inside of it, and found that there was some money missing. And so he assumed that the coworker that found the bag and turned it in had taken his money. He was very angry about it. He made it known to his employer that he was angry about it and upset by reporting it to some supervisors. And there was some suggestion that he was trying to set something up.
That the person who had gotten stolen from was trying to set something up?
Yeah, he asked his supervisor to set up a meeting in the parking lot. Things that,
Like, meet me on the,
yeah,
okay, meet me after recess type of thing?
Meet me at high noon.
yeah.
And is that what happened?
No, what ultimately happened is that he encountered the employee later, not because the employer set it up, but he encountered him later. He got his aunt, I think, to bring a gun to the parking lot, and he shot him.
So it was a parking lot on the premises.
That's my understanding.
Yeah,
I'll
I think that's right.
double check.
Yeah, I think that's right. That's why like all of the stuff about it is controversial because they didn't meet on the playground, right? They didn't meet. They didn't mean off premises. Like they in that case it would have been maybe different. But
this is definitely not a workers' comp case, right?
yeah, so that's where it gets complicated. Dwayne, would that be your first impression that it was a workers' comp case?
No, it's at work, but it's not. This is something totally separate. Would be my guess.
My first impression is okay. Well, I'm always going back to the basics for every scenario, and I'm saying, okay, well, if I'm injured because of the actions of another person, that person is responsible to me for my damages, right? And so, if I'm shot, right, and so I'm kind of now looking at this from the family's perspective, right? He died, the kid died, and so the family is saying, well, we're deprived of our child, and the estate, when there's a state claim, anyways, it's the person that shot him that is responsible initially for the damages. That person is a coworker that apparently doesn't have $400, right? I mean, I'll make too light of it, but like what we're looking for, Anne Marie, always is somebody who can pay.
Yeah, deeper pockets.
Deeper pockets, right? So,
so it's the employer's fault for not providing better security for his employees, right?
I mean,
well, and I think the argument in this case in particular was that the supervisors were on notice that there was potentially some, beef between the two employees, and there was nothing done to protect him.
Right, they knew or should have known that there was a problem.
Right.
But there's another issue here, Dwayne, and that is like agency, right? And
you use them big words again, Ben.
I know it's supposed to be even a short word, agency, right? Agency is like if let's just take an example. Let's say that I'm driving a motor vehicle and I'm working for you. You're my boss. I'm a lawyer. You're my boss. And I'm driving a motor vehicle and I rear end somebody. I was negligent. No question. I was answering an email, the 5th text message that you had sent me, plastering my phone, blowing up my phone with all kinds of where's this and where's that and did you file this brief, whatever. And I'm trying to respond to it while I'm driving. Boom, I hit this person, right? I'm obviously responsible to that person for their damages. But
you work for me.
That's right.
You were on the job. I'm responsible too, right?
That's right. And that's the agency thing is you're responsible for my negligent actions. And that's what's happening, I think, in this case, right, Anne Marie? Is like they're trying to, is that what they're trying to do?
Yeah, they're trying to impute some liability, although I do think they have some direct claims against the employer for failure to, if they were on notice of some potential harm that might come to their employee and the failure to intervene and assist him with that.
That's brilliant. I hadn't thought of that. Yeah. Right.
What's the benefits of that to the injured party?
Well, it depends. I mean, if you have a tort action against an employer, which it's typically, if you're injured on the job, the exclusive remedy is workers' compensation. And so what that means is your claim is handled in the workers' compensation courts. There's limited remedies. If you can file a tort action against someone in the regular court system, then you get the benefit of getting pain and suffering as one of your damages. You in workers' comp, your remedy is really limited at most to about 8 years, except for in special circumstances. And that means 8 years worth of your medical care and things like that as they relate to your on-the-job injury. So it's a very limited remedy under the Workers' Compensation Act. But if you have a significant injury and you can actually sue in tort, then your remedies really open up.
Right, and to pile onto that, right, I'm reading between the lines here, but I suspect what we know is that in workers' comp, if you die, right, the remedy is that your survivors get benefits. You don't get benefits. Your estate doesn't get benefits. If you're injured, if you're killed on the job, the person who got killed has no benefits.
Right.
Right. Their survivors do. And if this is a young kid that doesn't have any children, there essentially may not be any survivors, which means there may not be anything to get out if it was just a workers' comp claim.
Right.
Okay. So, but there's an exception. Right. let's play around with that scenario. Now let's say we were talking about me driving, working for you, and I rear end somebody. Let's say the person I rear end though is Anne Marie.
Y'all both work for me?
We both work for you.
Great. I got
Right.
great employees.
You have the best two lawyers you
No,
could possibly.
I am
like, work
balling
for-
big.
We're
Oh.
we're absolutely moving it, right?
Okay.
But I rear end Anne Marie's car.
Okay.
She gets injured. She's like, "Oh God, my neck!" Right?
Because it's really hurt.
Because it really is
There
hurt.
we go.
She probably has a brain injury. It's okay.
Happen.
Can she sue me?
Well, based on what y'all are saying, if y'all are both employees, then she can't.
That's right. Right? Because we're both working at the
I don't
time.
understand.
Well, here's why. It's the agency thing.
Okay.
But this is what Anne Marie was describing or talking about before we went.
Because I can't sue myself and we're both employees.
Exactly. All right. Because ultimately, what was it? The reason, what the public policy behind why you can't sue me.
What's the
Right.
public policy?
Well, you don't want businesses being burdened with a bunch of big tort suits made by their employees. The idea is to facilitate business, and the trade-off of that is that employers are responsible under the Workers' Compensation Act when their employees are injured at work. And so there's not supposed to be a real high bar to getting workers' compensation if you're at work and you're injured and you're
Right.
doing your job.
So we make it a little easier, but we add a little bit of protection for the businesses.
Yes.
Yep. Exactly right. All right. So we're back to that scenario. We've established she can't sue me because I'm an employee of the same employer. And because if you sued me, what you really want to be doing is getting at him,
Right.
right, through me. And because it's workers' comp, like that doesn't make sense. You can get you're compensated under workers' comp, but you can't also go through me to get compensated from the same person under the personal injury case. That's why. That's another why. Okay. But let's say now that it's completely different. Let's say that I rear end her car because she has a bumper sticker that says I brake for cannonballs, right? Or I brake for whatever. Okay. And I'm like, oh, that's a stupid bumper sticker. Nobody who has a bumper sticker like that should be allowed to be driving around on Atlanta streets. I'm going to rear end her, or I'm going to maybe, I'm going to rear end
hit her car on purpose.
I'm going to hit her car on purpose.
Okay.
Right. That changes everything, right? Why does that change everything?
Well, there's an exception. It's a very narrow exception to the Workers' Compensation Act, and it says that if you are injured because of the willful act, or
Like
the
intentional. Yeah. Okay.
intentional act of a third party, so another person, for reasons personal to you, then there's this very narrow exception where you can pursue a tort action.
Well, that's this case, right? I mean, he goes, gets the pistol, Aunt brings it. He's like, I'm going to kill you because you took my money, right?
Well, they raise a factual issue about whether or not it was work-related, and what they said was the whole dispute arose because of this $400, right?
And candidly, it did arise at work.
True, but then it
We-
needs to be in furtherance of the business as
Right.
well. I mean, that's the argument.
That's the whole thing is like
So if I was mad at you because you're making the shift line slow and you're causing us all not to be able to get our parts in quick enough because you're slow down there,
Yep,
and then I go, meet me in the parking lot and I shoot you, that wouldn't fall under this?
that would be workers' comp,
The argument
Whoa.
would be that was
I learned
work-related.
something new in this show every time.
right?
Yes.
Yeah, but it's only there's a super little nuance
Let's
to
make
this.
it super complicated.
Like we can make it even more complicated,
Right.
but it's only like that if you met in the parking lot of the premises,
Okay.
right? If you and I, let's say we had a dispute. In fact, I have this very case. I have a client. I totally forgot about this case. I've got a client who was working for the people who park the cars.
Valet.
Valet. Thank
Yeah.
you. Working for the valet, and apparently the other valet driver was like really pissed off at my client because he wasn't like parking the cars right. I don't know what is. No one really knows why he was mad, but they both decide to meet at somebody else's house, not on the premises, not on wherever. They meet someplace completely off the clock and off whatever. And the other guy like hauls off and hits my client and breaks his nose. The question is it a work injury? Is it a workers' comp injury? And the answer is, well, no, because it didn't happen at work. Even though these guys are like mad at each other because of how work happened, like it's not a workers' comp injury because it didn't happen at work, right?
Fascinating.
Yes. Had it happened at work, it would be absolutely work related and a workers' comp and a workers' comp claim.
Right.
Right. So in this case, right, the controversy is who gets to decide whether it arose out of work or something purely personal.
Yeah. And let
What are
me
the
add
possibilities?
well, the facts of the case, the argument is because what the defendants are saying is because he was trained on the job to turn in lost items, that it was a work-related function that he was performing. It's work-related, therefore the Workers' Compensation Act applies.
These sneaky defense attorneys.
That is clever.
That's
clever,
very
yeah.
clever.
The plaintiff's saying that this stolen money had nothing to do with his employment, and therefore, so that's the factual issue, and that's what they want to get to the jury, is you guys decide, was this work-related or not?
Right. Whether it's purely personal.
Yeah.
And that
Or
makes
not
sense to
purely
me. You get a
personal.
factual issue, that doesn't need to go in front of the workers' comp judge. That needs to go to a jury, right?
Well, we're going to find out.
That traditionally, if you grew up like we did in the workers' compensation system, we would have 10 years ago, we would have said, oh, absolutely, the workers' comp board has to decide whether this is purely personal or arose out of the employment. We would have said they have the exclusive jurisdiction of deciding whether it arose out of the employment or not, that the workers' comp board does.
So this is a freaking cliffhanger. I don't get to find out how
No,
it is.
we don't. We don't know how
Why
it's.
would you do
We
that
don't know
to
how
me,
it's going to
man?
turn out. So these clever attorneys
Yes.
said, "Look, the workers' comp board doesn't have to decide whether, in every case, whether it rose out of the employment or rose out of purely personal reasons. A jury can decide that, and that's what we want. We want the jury to decide that." So you had something similar come up in one of your cases. Is that right?
I did, yeah.
Are
Yeah,
you at liberty to talk about it, or is it still pending? Or,
No, it's resolved.
Okay.
We had a client who was assaulted when she was on a work-related trip, and so we spent a lot of time when we were preparing the pleadings, and that's what you file with the court in order to initiate the lawsuit. We didn't want the workers' comp bar to apply, and so
Right, you didn't want it to be workers' comp.
correct.
Right.
She was assaulted by a coworker, and so we were invoking that really narrow exception of it was a willful act by a third party that was personal to her. And in doing, we just had to be very careful about how we pled it because there are a lot of avenues to get it just kicked out of the state court and kicked back to the workers' compensation court.
Now, have you found, this is kind of like maybe a really insider practice pointer, but have you found that the liability defense attorneys really don't have a full understanding of how powerful the workers' comp bar is?
Oh, for sure. Yeah.
Yeah.
And I was reading over those pleadings in my case, and I was rereading the motions, and I was, thinking about things they probably could have said that maybe would have been a bit more persuasive to get it kicked out of the state court and into the workers' comp court. But
Yeah, I have that
But
come up.
they didn't think of
They
it.
didn't
they
think of
got
it.
some good arguments, but we
Yeah.
battled through the motions. And
I had that come up with a case that with a client that you referred to us, and you were asking us, well, can this be a personal injury case instead of a workers' comp case? And my answer was, it depends on how clever the other side is, right? If they figure out this argument, we're pretty well screwed, right? But if they don't figure this out, I think it should be a personal injury case, but it depends on whether they think of the argument. It's the same thing that comes up in a statute of limitations defense, right? Statute of limitations defense only works
If you bring it up.
if they raise it and argue it, right? Yeah. Well, thank you for joining us. It's been really fun, good times. I'm still not quite sure I understand all of the nuances to this. It is really complicated, but I mean, we get those kinds of questions from clients kind of all the time. Like
Right.
this stuff happens at work. Is it work related? Is it not work related? We had that happen with our client was walking into a manufacturing plant, got hit by another driver as a pedestrian while she was on the premises. And the workers' comp people, we actually kind of wanted it to be both workers' comp and personal injury. You can, because the person that hit her was not an employee. And so we wanted it to be both workers' comp and personal injury. And the workers' comp people were like, no, she wasn't on the clock yet. And I thought, yeah, okay, we'll see about that. And so anyway, we got that one resolved. Anyways, thank you for joining us.
Yeah, thanks
Very
for having
interesting
me.
as always. Make sure that you subscribe and you like us and you share us on social media. Where the Bob and Irreverent D Talk Law
Click the
podcast.
bell. Click the bell.
Yes, click it. Bye.
Thanks for listening. Tune in next time when Bob and Irreverent D talk law.